Good evening, everybody. Good evening. All right, let's start. If something is illegal, why will there be any legal provisions for the same? We are now going to spend some time for the first 15-20 minutes or so, and we are going to understand primarily the rights concerning the, the fourth estate. Now, as you would know, and you would often quote this in your essays, that while the legislature, the executive, and the judiciary are the three branches of government, it is the media which is often considered to be the fourth estate of democracy, the fourth branch of democracy. It is often called the fourth estate. This is a commonly used term to signify the role played by the media in upholding democratic notions in a given country. Okay? Now, once we understand this and we understand this carefully, we're looking at two basic components of press rights or media rights. We're looking at the rights individually as far as journalists are concerned, and secondly, we're also looking at the rights very specifically to press organizations. To press organizations. Now, these include both print and electronic media, print and electronic press, print and electronic press. Now, what is extremely interesting to note here is a few basic concepts. I'll first start with journalists. An analytical point of discussion could be that journalists enjoy the exact same amount of fundamental rights as an ordinary citizen does. Now, while you might think that is a good notion to believe in, several experts and several scholars tend to think otherwise. In India, we have no special law, no special rights, no special legal provisions protecting the journalists for the job that they do. Now, if somebody is in the business of giving an opinion on government policies, then there must be special protections to ensure that the government does not abuse the law, thereby protecting the fourth estate, which is the media in a democracy. If you think about it, an idealistic notion of journalism is basically permanent whistle blowing. An idealistic notion of journalism is basically permanent whistle blowing. Now, whistleblowing is an act of exposing some discrepancies within a department. And that's exactly what a journalist is supposed to do. And that is why journalism and the true essence of journalism is often considered one of the most noble professions in the world. Unfortunately, the times that we live in, there have been several issues of fake news, paid news, biased news, which have compromised the very integrity of journalism, which is why in your paper 4 you would also study something called media ethics. Now, when we do talk about journalists, the reason this particularly has been in the news is because of the issue of Pegasus. Now, the issue of Pegasus affects both Article 19 and Article 21 for journalists. Very simply, I'm sure all of you know the technical details, but very simply, Pegasus is basically a spying software which is manufactured by an Israeli defense firm who has been authorized by the Israeli government only to sell the software to other governments, which means the sale of Pegasus to non-state actors is prohibited, as the government of Israel has said so in their official statement. Now, very recently, an international consortium of journalists, of which there were a few Indian news agencies who were a part of, conducted a very, very deep dive kind of an investigation. And it was found that several powerful individuals or several important individuals all across the world, all across the world were being spied on using Pegasus by the government. Now, this is on the basis of a report which has been given as a part of this internationally collaborative journalistic exercise. What is also remarkable to understand as far as the Pegasus software is concerned is the fact that this Pegasus software, or, or Pegasus as we would know it, does not require any physical contact, at all under any circumstances, okay, to be installed onto a mobile device. In fact, it could be done over the air, even if somebody inadvertently clicks over a link or other means, which is why it becomes an extremely cutting edge and a potentially powerful software. When the details of this were released about India, it was alleged that several politicians, both within the government and the opposition, journalists, lawyers, social activists, think tank founders, corporate heads, all the who's and who of power and politics and money in the country, quite a few of them were having their devices infected with the Pegasus software. Now, very interestingly, this is where it gets better. A public interest litigation has been filed by somebody called Manohar Lal Sharma. The case is currently pending in the Supreme Court, and along with Manohar Lal Sharma, several other co-petitioners also exist whose phones have been hacked using the Pegasus software. Now, the Supreme Court is currently hearing the matter and has in the process of hearing the matter issued what is called an interim order. An interim order is an order while the case is in progress at a court of law. And the Supreme Court has said that they are appointing a committee which is going to examine whether this was an authorized use and to what extent is the authorization valid. The committee will submit its report to the Supreme Court, on the basis of which we could expect a certain amount of judicial clarity. Now, these are the facts. Now, when we apply these facts to journalists, we must understand this. The unwritten code of journalism is that there is a very, very holy relationship between the journalist and the source of the journalist, who informs the journalist about certain events and happenings which the journalist would then quote in the process of it all, right? Which the journalist would therefore quote in the newspapers or in the media as such. Now, when the phone of the journalist is being spied upon by the government, two things happen. One, the identity of the source or of the informant of the journalist is compromised, therefore, putting a sense of threat to the identity of the informer and to the informer thereafter. And two, it also creates a threat to the journalist, and the journalist would then therefore be consciously aware of not reporting stories which would be a little too critical of the government in power at the time. So this is why this Pegasus issue, while no doubt is a privacy issue, that how could you know, perform surveillance on somebody's phone which contains personal information and personal communication that a person has with somebody, but it also, more importantly, it also is a question on journalistic integrity, thereby compromising the freedom of speech and expression, as the journalist would be scared to report stories which may or may not land the journalist in trouble. So, as far as specific journalists are concerned, this is what your media rights are about. Now, very interestingly, there isn't a lot of Supreme Court jurisprudence or a lot of Supreme Court judgments on the rights of journalists per se. A lot of the judgments that we are referring to are judgments which are declaring certain laws or certain orders given by the government as unconstitutional, as they restrict the way press organizations should be functioning. Because when we look at press organizations, no doubt there is an element of journalism involved, but the press organizations are also covered under Article 19 Clause 1 Article 19 Clause 1 Clause G, wherein you have the freedom of trade, business, occupation, and so on and so forth. It is also very interesting to note that most of the Supreme Court judgments are at a point of time, are to the point, are to that extent where electronic press had really not evolved at that junction. Okay, so you do not see a lot of you don't see a lot of what is called Supreme Court jurisprudence on news channels, on let us say private on online news platforms. The landmark Supreme Court judgments that we would be referring to would of course be leading to a lot of these discussions. Now, apart from this, there is of course a tad bit of politics in place. For example, I am sure you would have definitely heard of certain independent news media outlets. For example, The Wire, for example, News Laundry, for example, Alt News. Now, all of these pride themselves as independent online outlets who are largely dependent on subscriptions by ordinary citizens like you and me, and therefore they are not dependent on advertisers. And because they are not dependent on advertisers, so they don't have to play stories which are in favor of the advertisers or are away from sort of governmental control. Now, a lot of times, some of the stories that have been done by some of these organizations have been very, very critical in nature, and they have been responded with defamation suits seeking compensation for the stories that they have done. Some examples that do come to mind with respect to these are, for example, when The Wire a few years ago had done a sort of an expose of sorts, or sort of a story on how the BJP has wealthy business houses being indirectly represented in the Rajya Sabha. There was a story that they had done on the Home Minister's son. There was sometimes there are also rivalries between channels where Aaj Tak had filed a heavy defamation suit against News Laundry. Now, so these are political, these are controversial in nature, and of course, somewhere they do affect the freedom of the press. But when we look at the jurisprudence, when we look at the law, we understand that most of it is concerned with the print medium. Also, because whether it's a news channel, so the news channel is basically on TV, and you have the TV and the Cable Networks Act, which covers news channels, right? So there is a legislation, and that's one of your most important points to understand, that we do not have a specific law governing the conduct of TV news channels. They're covered under the larger umbrella law, which applies to censorship on all forms of TV programs, whether they're entertainment, adventure, reality, news, or sports in general. So, we're going to spend some time here. I will discuss some of the cases with you, tell you what these cases were about, and of course, we'll get down to our discussions. So, this is the larger context to this. I'll take you back to the slides, and then we can understand what it is that we are referring to. Now, when we do talk about the freedom of the press, when we do talk about the freedom of the press, we understand that we must also look at some of the context that develops from our Constituent Assembly debates. Now, this was, of course, a very hotly debated idea in the Constituent Assembly, and one of the members of the Constituent Assembly, Damodar S. Seth. Now, you could quote this in a 12 and a half marker, or you could write this in an essay. But for you to write this in a 10 marker would be a little far-fetched. Now, one of the members of the Constituent Assembly, Damodar S. Seth, had very explicitly argued in black and white that press rights or journalistic rights must be explicitly included, given the fact that the press is going to be the one keeping the government accountable. Now, of course, through a lot of debate and discussion, it was understood in the wisdom of the Constituent Assembly that there was no need to specifically write about the rights of press as a fundamental right, because they would be indirectly covered under Article 19. You are absolutely free to disagree with this. You, in fact, should disagree with this, and you can draw an analogy that if you can have affirmative rights on minority institutions, if you can be as specific as abolition of titles under equality, then you can definitely write about the rights of journalists under, fundamental rights of Article 19. Now, a correlative right to the freedom of press is that once you have information, you also have the right to report and broadcast it. It becomes extremely important today, given the fact that social media is in fact a new reality, and we are living in the digital age. If you see the number of people doing extraordinary work on YouTube with their analysis of current affairs, and I'm not talking about daily current affairs UPSC YouTube channels. I am talking about news and news shows that often come on YouTube, right? Some of them are exceptionally good, genuinely very good. So, and across the board, sometimes you will also see, just give me a second, please. I just need to have a glass of water. Right. So this is something that we must understand. Like for example, yes, Truvrati and so on and so forth are very good examples, especially in the times that we live in, especially in the context of the times that we live in. Unquestionably, there is a lot that goes on, and of course, you have. Dhruv Rathi is very political in nature. I don't want to comment on it, but you have some very good channels who are doing some very good work. Brute India, Vox India, Think School. Some of them are doing extremely good work with respect to current affairs. People are now starting to give investment advice, financial advice. That is also in one way or another, imparting information. So what you must understand today is that the traditional notion of a journalist, a traditional notion of a journalist who is working for an organization which broadcasts the news on TV, that notion today is diluting. Shekhar Gupta's Cut the Clutter on the Quint channel is fantastic. Palki's, 10-minute sort of primers on Bion are very good, genuinely very good. She's also a journalist that I'm particularly fond of. Very good. Both Shekhar Gupta and Palki, exceptionally, good journalists in their own right. So these are the things that we must always remember. So the idea that you must write in your answers is this: that the traditional notion of a journalist and the traditional notion of the medium of press, that has now changed because of technology, which is why there's all the more need for some kind of a regulatory and a protective framework so that the interests of all stakeholders are very clearly managed, right? Okay. Now, so this is that. Now that we understand this, we'll get into some of the judgments and just give you all that you need to know, right? Let's start. Romesh Thapar. Now, a brief history of the Romesh Thapar case is very interesting. So this is the first possible Supreme Court judgment, and that also in the very first year, of the Constitution being into force. The Romesh Thapar versus State of Madras case is where Romesh Thapar was the editor, the publisher, the writer of a journal which was based out of Bombay. And the journal was exceptionally good in terms of its articles, in terms of what it wanted to sort of bring across. And very interestingly, there was a law in Madras which prevented, which prohibited the distribution of journals which are not from Tamil Nadu, from Madras back in the day, which is of course now Tamil Nadu. Now, this journal that we are calling, this used to be called Crossroads, was an English journal, and basically the distribution of this journal was restricted under a local Tamil Nadu law, Public Order Maintenance Act, something. So Romesh Thapar challenged this law in the court, saying, you are restricting the distribution of my journal because you think it is going to cause disharmony or any of it without even reading it, without even letting the people make a decision for themselves. Because of which the Supreme Court struck the Madras law down and very clearly held that the freedom of speech and expression also includes the freedom to propagate ideas, which is through the freedom of the circulation of a publication. And therefore, it was also declared that the freedom of the speech and press is the foundation of all democratic institutions, right? You don't need to know the details of the case beyond a point, but this is okay. Now, Sakal newspapers. But the thing is, when I tell you the facts of the case, it's easy for you to, relate to what happened. It's very easy for you to understand what happened, right? You are able to visualize it, you're able to contextualize it. Now, the Sakal newspapers case is a 1962 case, and from the name Sakal, you would be able to deduce, you'll be able to understand that this is a Marathi newspaper, and the basic problem with this was that it was basically, there were governmental regulations wherein there were restrictions on the number of advertisements that you could put in the newspaper, and there were restrictions on where you could put those where you could put those advertisements in the newspaper. This was actually done through the Press Act, which was set up after the recommendations of the Press Commission in the late 50s, early 60s, and that's how this case actually happened. So you had the Newspaper Act of 1956, and the order came out in 1960, where the order said that you cannot, oh right, there is a black screen. I think it's back now. Now that, so I'll repeat the facts again. Sakal newspapers is essentially by a company called Sakal, which is a publishing company which prints Marathi newspapers. Now, what had happened was that the newspaper had allocated about 40% of its space, 40% of its screen, of its number of pages to advertisements. Now, the rest of it was, of course, for news and articles and editorials. So the government came up with an order in 1960, right? The government came up with an order in 1960 wherein the government put restrictions on that, you can't have so many advertisements, and you can't have, such commercialization, you're doing a noble job, and so on and so forth. Now, because of this, the Sakal newspapers, of course, challenged the central government order in the Supreme Court. The Supreme Court said, boss, now please understand this. They are a business entity. If they are providing advertorial newspapers, if they're providing heavy advertisements instead of heavy newspaper reporting, it's their call. It is for the people to judge, not you and I. So let them be. Let them do what they want to. The Supreme Court very clearly said you have the right to freedom of speech and expression. You don't have the right to effective or meaningful expression. What may be effective and meaningful to you may not be effective and meaningful to me. Somebody may really want to see that ad. Somebody may really want the product that the ad is trying to advertise. So that is okay. So don't get into these things. Don't bother with these expressions. Now, then in 73 and 86, Bennett Coleman is the company that owns Times of India, and Indian Express, of course, we know what they are. Now, very interestingly, the Bennett Coleman case and the Indian Express case also had similar implications on restrictions of press rights. There were several orders that were issued, and they were very specifically for the press industry. So they were also again challenged, and the Supreme Court said that okay, we are striking down these rules and don't worry about it. And these rights are also extendable to corporations. Corporations and media corporations and journalistic corporations also enjoy the same kind of rights as everybody else. And therefore, any limitation that you put on press rights, which is beyond the restrictions of Article 19, Clause 2, are not valid. You can't club the restrictions from 10 other fundamental rights and say this is why we are banning your newspaper, or these are the restrictions that we are going to give as far as your as far as your newspaper is concerned. Okay, do we understand this? Is this fine? I'm just checking the internet connection. It seems to be okay. Just give me 1 minute. I'll just check. It seems to be okay. Okay. The internet seems to work. All right. So I'll quickly run you through the facts of the Bennett and Coleman case. So the Bennett and Coleman case is basically about the Times of India group. For some of you who've ever seen a Times of India newspaper, you will still see the logo of Bennett Coleman and Co Limited right at the top of the newspaper. So as you would know, Bennett Coleman and Co are nothing but media conglomerates in India, and they are a very, very big news organization. So what basically what had happened was that there was an import order of 1955. There was a restriction control order of 1972-1973 under the newsprint policy, which basically placed several restrictions on newspaper companies. So those restrictions were, for example, if I remember correctly, no newspaper could be started by a company if you already have two existing newspapers and one of them is a daily newspaper. So you're restricting the number of newspapers a media company can have. Two, I remember the total number of pages should not exceed 10. The third, that the number of pages should not be more than 20%. If they are more than 10, and for that you will require government intervention or government sort of a restriction of some sort. We're basically restricting the agency in itself, and that is something that they challenged. And when they challenged, the Supreme Court said, of course. Now the government said freedom of speech is for citizens. Is a company a citizen? To which the Supreme Court said, absolutely. You, through restricting the rights of the companies to have multiple newspapers, you are restricting the rights of the citizens to actually run the business they want to. So you cannot say things like these under any circumstances, and that is how this case came to being. Okay, that is how this case came to being. Now, very interestingly, when we now look at the Indian Express versus the Union of India case of 1986, you must understand that in the 70s, now this is very interesting. We are talking about the year 1972 to 1973. You would have often heard that during the emergency, the press was, severely battered down. During 1972 to 1973, the government had actually come up with something called the newsprint policy, which basically restricted news organizations in the country. This also overlaps as far as this also overlaps as far as the freedom of the press is concerned, the freedom of a person to run a business the way they want to is concerned. So a lot of these cases, Bennett Coleman and Times of India, are actually correlated to all of these things. Right? Now let's understand this. Now what had basically happened was this newsprint policy had several implications. One of the other implications was with what is called the Indian Express case. So what happened in the Indian Express case was that there were actually some additional duties. So sometimes you have to order the ink that is used in newspapers. Sometimes you have to import that ink. You have to import the paper sometimes in case if it's of a certain quality. Now that means you have to pay import duties on it. Nowadays it's all self-sustainable, but back in the day we were running a different scenario. So there were basically a higher import duty which was levied under the Customs Tariff Act, and some additional auxiliary duties under the Finance Act of 1981. The Custom Tariff Act was 1975, and the Finance Act at that time was of 1981, right? And therefore what had happened was these basically put import duties for newspapers. Before this, there were no import duties if the newspapers were importing ink or material for the publication of the newspaper. That obviously will shoot up the cost of the newspaper, and every penny counts. So that is why it was challenged, and that is why the Supreme Court said that these rights are also available to corporations and not just press people or individuals. I don't know, I get very fascinated when I study, when I teach case law and I teach what happened in a case law to tell you what the law today is. Otherwise, it's very easy for me to tell you XYZ case, this is what the Supreme Court held. You only need to know this is what the Supreme Court held. But when you know about a 5-minute background, that this is what happened because of which we are discussing this, it adds so much gravitas, it adds so much insight into the things that we are really talking about. Now, the Menka Gandhi case I'll do separately after 21, because Menka Gandhi case, as I told you, is about the golden relationship of 14, 19 and 21. So let's leave this case for now, and then you can correlate it later. So let's leave the Menka Gandhi case, an extremely important case, but we'll do that case a little later. Now, certain contemporary judgments, when we look at the PUCL case of 1997, it was in this case where a law of the government was challenged, Telegraph Act, which basically permitted the government to wiretap conversations. So a very, very old and very popular non-state actor, civic society and an NGO called Public Union for Civil Liberties had filed a petition, and the Supreme Court declared that any illegal wiretapping is a violation of speech and expression, unless of course it comes under the grounds of reasonable restrictions. Now, what you must also understand with the PUCL case is that the PUCL case also gives us a very contemporary insight with respect to Pegasus. And I mean, if you think about it, it also gives a lot of contemporary insight into Pegasus, because if you think about it, Pegasus is also about surveillance, it's also about snooping. The medium has changed, the technology has changed, the mechanism has changed, but at the end of the day, the factors still remain the same, the reasons still remain the same, the illegality still remains the same. So the PUCL case, as we would know it, the 1997 case, is essentially a case that really puts things into a certain context. Okay, do we understand this? Is this fine? Okay, all right. Now, very recently, in the Union of India versus Association for Democratic Reforms, the Supreme Court also observed that any one-sided fact, any disinformation, misinformation and non-information all lead to democracy is a farce. Just because you have the right to say whatever you want to doesn't mean that you will say whatever you had to. This was in the several instances of paid news, fake news, altered news, sponsored news, right? No, you don't have to mention any details at all. Anupam, don't worry, just enjoy the learning process. Then there was, of course, the Rakesh Om Prakash Mehra versus Delhi in 2013. This was a case, you would remember Rakesh Om Prakash Mehra, who was also the director of a very popular movie called Rang De Basanti, and in which the Supreme Court had observed that you not only have the right to freedom of expression while you are expressing it, but also after you have said what you have said, which means people can't come beat you up, can't send you to jail, can't take action against you just because you've said something which is reasonable in nature. And as long as it is reasonable in nature, nobody is going to really question what was said, why it was said, and so on and so forth. So that is something that you must understand in the ecosystem. Okay? All right. Now, a very popular case which happened in the Shreya Singhal case of 2014. Now, this has been asked in the UPSC before. This was in the news recently, but don't worry about it. It was in the news for completely different reasons. So, So let's understand this, and let's look at it from a larger point of view. Okay, uh, so when we look at it, the Supreme Court had basically struck down Section 66A. Now, what was 66A? Section 66A of the IT Act basically provided for the state to take criminal action against anyone who was publishing any information against the state in an online medium, which was of course causing a communal or any sort of societal imbalance. Now, this was to be used in the rarest of the rare case. This was the original intention was people should not use the online medium to spread hate online, to spread communalism online, and so on and so forth. Unfortunately, people started doing so. Unfortunately, people started abusing it. But at the same time, so did the government. Now, the government started using this provision to penalize people who were disagreeing with the government, who were disagreeing with the outcomes of the government, with the policies of the government, with respect to, say, a law or a scheme or any of those things. Several cartoonists, comedians, a lot of people, were getting jailed because of this. Now, what is this case is actually very simple. Shreya Singhal was a 21-year old lawyer. She filed a PIL, and she obviously comes from a very prosperous legal family. Now, what basically had happened in this case, the backdrop of this case was, the police had arrested two women in Mumbai for posting what was allegedly offensive and objectionable about shutting down the city after the death of a political leader, Thackeray. Now, this was done under Section 66A of the IT Act, which basically punishes anyone who uses a computer resource or electronic information, and to spread any information which is offensive or incomplete or so on and so forth. Right. So that is something that we must understand. That is something that was the context of it. Now, the Supreme Court very clearly said that it violates Article 19, and therefore we will not let this provision continue. So, Supreme Court declared this as unconstitutional. It was in the news last year because there was an organization called the Internet Freedom Foundation, which did a lot of research and found out that despite the fact that the Supreme Court had declared Section 66A as unconstitutional, there were several cases which were still being filed at police stations using Section 66A. This was a gross violation of the Supreme Court order. Now, you could also call it contempt if you'd like to, but you must understand why this was happening. This was happening because it was an implementation failure. The official IT Act still contains Section 66A. It has not been deleted by the Parliament through a repealing law. So police officers who have the IT Act still have Section 66A written in it. So people just don't know that, this law does not exist. The Supreme Court had directed the government to, inform all the chief secretaries and the DGPs of every state to ensure that adequate information has been disseminated to the local police authorities, but that did not happen. And thirdly, there is also no official procedure of Supreme Court judgments being, discussed, or there is no official sort of a mechanism of Supreme Court judgments which are actually reaching out to all the lower courts. So the lower courts also are not aware. So this was not a Section 66A issue. It was an issue of the awareness of Supreme Court decisions as to why this was in the news last year. And this is not an isolated incident. I am reminded of another provision in the IPC which basically said that if somebody had life imprisonment and they committed murder in jail, then they would directly be given death penalty. The Supreme Court had clearly struck this provision down, saying that you're violating what is called double jeopardy. You are basically deciding a person's crime on the basis of previous crimes, and that should not be done. It's also a violation of the right to equality. Now, of course, people were not aware of this. So, a court in Rajasthan actually convicted a person under this provision and sentenced the person to death penalty. Thankfully, all death penalties have to be confirmed by the High Court of a specific state, and that is why the Rajasthan High Court, while reviewing the death penalty, thankfully found out that, boss, you're absolutely right. This law does not exist. So you can't put a person on capital punishment for a law that does not exist. And that is exactly what we needed to do, right? So that is that. Now, in the Anuradha Bhasin versus Union of India case of 2020, this is also something which is very interesting. The Supreme Court had basically ruled that the freedom to access the internet is a fundamental right and is therefore protected under Article 19, Clause 1, Clause A. And this was basically challenging the internet shutdown orders, as far as uh, as far as Article 19 is concerned, right? So these are some contemporary judgments that you should know as far as Article 19 is concerned, as far as the basics are concerned. Now, once we are done with this, you can take a 5-minute break, and then we will continue with the last part, the derivative part, wherein we look at basics of right to information, the freedom of silence, and also the right to internet access. That's also something that we will get into under freedom of speech and expression. Okay, all right. All right. Let's continue. We're now going to look at some derivative rights, specifically, good evening, yes, nothing happened, Abhishek, I'm fine. Okay, thank you. Now let's look at some derivative rights that could be implied from Article 19. Okay, the first, of course, is the right to be informed. It is the right to be informed. Now let's understand this. It is deeper than what most people think it to be. Thank you, Ashish. It's very kind of you. Thank you. Okay. We were just talking about Bayan a while ago. Anyways, so the right to be informed has multiple interpretations in a democratic setup. The first is, of course, a general right to know about the proceedings, the progress, and the development of the country. Right? That's the first one. Now let's understand this as clearly as possible. Right? Now, as we were talking about this in the first set of our discussions on Article 19, we were able to understand as clearly as we could, we were able to understand that, boss, we as citizens have a right, a fundamental right, a very clear fundamental right to know about what happens with the government. We also have a right to question the government. We have a right to have an opinion about the government. Now, if we have a right to have an opinion about the government, then in that scenario, we must also have the right to have the right kind of information on the basis of which we can have an opinion on the government. Okay, now here is the thing. It is because of this concept that under several cases, in fact, Bennett Coleman was one of the cases, where the Supreme Court has repeatedly held that the right to information should therefore be a fundamental right implied under Article 19. And this becomes one of India's most powerful measures if used correctively, to actually combat corruption. If used extensively and effectively to combat corruption. Okay. Now, interestingly enough, the journey of right to information, in fact, is one of those rare journeys where the states have done a lot about this before the center has. So there were several right to information acts of several states before we ended up having a National Right to Information Act, because this comes under concurrent list. So both the center and the states can make an ordinary right. So while the right to information is an implied fundamental right under Article 19, it is being guaranteed through an ordinary legislative law. And the people who should be credited with this are actually the Mazdoor Kisan Shakti Sangh, who basically started this movement in Rajasthan to question how land records were being maintained in the context of land reforms that were being happening in Rajasthan. So here also you will see that at some point of time, land reforms have played a role in the evolution of right to information. So that of course is an important point. The second is, no doubt we have the right to know about the proceeds of our government. We also have the right to know about the representatives of the government, and by extension, the right to know about the candidates who are contesting an election. This becomes an extremely tricky right, because what you're basically saying is person X wants to fight an MP election and I want to know about person X. This person X is a private person, still has not won the MP election. So therefore it becomes very tricky. But same organization PUCL in 2003 went to the Supreme Court, and the Supreme Court declared that from now on candidates must submit their criminal and financial information while filing their nominations, and after they have been elected, they must submit a detailed financial analysis of their assets after they have been elected. This also applies to you. All of you, once you clear the civil services, you will also have to declare what is called a movable and an immovable property return, and this is publicly accessible. So please be very careful. Yes, you will have to fill this return within the first month of Labasna, and every year you will have to keep updating this return. And I, an ordinary private citizen, can look into this, can find out what's happening, and can therefore see how much money you have in your bank, how much gold you have, how much jewelry you have. So this right to be informed now applies not only to your legislatures, not only to your elected executive, but also a permanent executive. The origin of all of this still happens to be the right to be informed. That is why when you enacted the Right to Information Act, you also included provisions of voluntary disclosures. Why do you think ministries release annual reports? Why do you think PIB exists? Why do you think ministerial websites exist? Because they're informing you about things that they are doing even before you ask them what they are doing. Then of course you can ask very specific questions. Okay, so details of this we will do when we do bodies and Central Information Commission and State Information Commission, all of those things. What you should know is Central Information Commission is not a superior body to State Information Commission. Please know this, they're two separate bodies. Okay, Central Information Commission is right to information for central institutions. State Information Commission is your highest body for that state, for information about that state. They are not appellate bodies to each other per se. So this is of course the right to be informed. Now, if you have the freedom to speech, then you also have what is called the freedom of silence. Now in your notes I have mentioned the Bijoy Emanuel case, and that case pretty much sums it up very well. So you see, what happened in the Bijoy Emanuel case was that there were two students at a school in Kerala who stood up while the national anthem was being sung, but they did not sing the national anthem. As a result of which, the school suspended those students. The students challenged the suspension of the school, and the Supreme Court very clearly held that there is no violation of the law. The law very, very clearly says that, boss, you have to stand up if you can when the national anthem is to be played. and the law for that is called the Prevention of Insults to the National Honors Act of 1971. Okay, that's the law that we know. Fair enough. Now, interestingly enough and correlative, just because a person did not sing doesn't mean that a person disrespected the national anthem. So, in the Bijoy Emmanuel case, in the Bijoy Emmanuel case, the Supreme Court held that the freedom of speech and expression also includes the freedom of silence. Right? Now comes the third part, the more contemporary part, more likely to be asked in your exam with respect to internet. You see, internet is a very funny thing, right? Internet today has also become a medium of expression. Internet today has also become a medium of garnering information. It's not just about giving information, but it's also about garnering information, right? And that is something that we must understand. And if this is the internet that we are talking about, if this is the internet that we are referring to, then the internet no longer is supposed to be a privilege. It is how people are getting educated, and especially in the post-pandemic times, it is how people are getting educated. It is how most people are getting information about the pandemic, about lockdowns, about restrictions, about everything. Today, if you are able to order groceries home, which is a necessity, it's because of the internet in the pandemic, right? Today, work from home is why most people are still able to work. And what do you need to work from home? Internet. So, internet today is a medium, an information provider, an information seeker, and at the same time, a sustainability factor. Which then raises a question, what about the right to internet? Okay, what about the right to internet? Now you would remember we discussed something called a positive right and a negative right. Okay, now when we say that the right to internet is a positive right, this means that if you don't have internet, it is the job of the government to make sure that you have internet. This could be a heavy financial cost. It could be an unbearable financial cost, and that is something which should not be tolerated. And therefore, in that context, the Supreme Court has very clearly held that you have the right to internet to the limit that arbitrary internet shutdowns will be illegal. If the government does not have a reasonable basis to shut internet services in your area, that is a valid right. But to ask for internet services from the government because we cannot afford it or because it's difficult, that would be too far-fetched. This becomes, very interesting an observation, because for example today, the only way you can fill a UPSC form is online. There is no other way. The only way you can fill a UPSC form is online. The RBI grade B exam is a completely online exam. So for somebody who's not digitally literate and therefore has to appear in a computerized exam is automatically at a disadvantage as opposed to anybody else who's grown up with internet and the computers. So it becomes a very sensitive right to actually deal with, right? Understood this, right? Of course, public information, not personal information. Those are reasonable restrictions, Chandra. So when we say that you have the right to internet, what is it that we mean? That your right to internet includes your right against arbitrary internet shutdowns. It does not mean access to internet. However, The Kerala High Court has recently held that internet is a necessity. So let us see how the Supreme Court responds to this and what kind of jurisprudence are we able to extract out of the Supreme Court. Okay, are we fine with this? Yes. So this effectively covers everything that we need to know as far as Article 19 is concerned. Now, I am going to now move to Article 21 and get to everything else. Yes, Kannav. I like how activistic you are. We're now going to look at Article 21 and of course Article 21A. Now, let's go to the text of the Constitution so that we understand what it is that we're dealing with. As far as the right to internet is concerned, you will find a page-long note on it so that you know exactly what to write as far as the exam is concerned. Yeah, so here, I'll quickly run you through this just in case you want to. So, the right to internet access and the right to speak freely and express oneself over the internet are essentially positive and yes, Vivek, are correlative. We again come back to the 2020 Anuradha Bhasin judgment, where it has been clearly held that it is a negative right, which means you cannot arbitrarily shut internet down. But when you apply the Puttaswamy judgment to right to privacy, we understand that that reasonable restriction has to be reasonable enough, right? Because you're shutting down internet, you're shutting down economic activity, you're shutting down a lot of other things for people which emanate out of the internet. So that is why the Puttaswamy judgment came up with something called the proportionality test, that you want to restrict internet, you want to restrict privacy, do that. But you have to make sure it should be done with a law. The reason you are making the law and the objective that you want to achieve with that law, they must be correlative. And the kind of restriction you want to introduce, the kind of restriction you want to implement, they should also be justified. And you must also make sure that the restrictions are legitimate in their own right. They are necessary in their own right, and it should not give too many powers to the state for it to abuse. Okay. Then you would look at some of the Kerala judgments that I was talking about. Here is this judgment. So in Fahima Shireen in 2019 in Kerala, the High Court said that mobile phones and internet access is essential, it's a necessity, it's a part and parcel of day-to-day life. Even internationally, resolutions adopted by the UN Human Rights Council and General Assembly say that internet is the key to accessing information and is of course linked to education and knowledge. Now, what should your conclusion be? See, technology is an enabler of rights and not a right in itself. And therefore, the meaningful exercise of exercising freedom of speech over the internet is always dependent on whether you have access to infrastructure or not. When we study the second part of IT rules, where we talk about the originator problem with respect to privacy, you will understand that not even 10% of India is on Twitter, right? Of course, the WhatsApp base of India is the largest in the world. Facebook and Instagram, of course, are heightened aspects. But well, social media is a very minimalistic view. So if you think the view of the country is what it is on Twitter, you are extremely mistaken, because that's exactly what happened during Trump's election. Everybody on social media thought Trump is going to lose. But for some reason, President Trump is President Trump, right? And so we are saying basically your freedom of speech and expression over the internet depends on infrastructure, and infrastructure then depends on socio-economic factors such as distribution of resources, access to certain policies, access to certain benefits, affordability, economic factors, and so on and so forth. Okay, understood this? Are we clear with this? Do we get this part right? Okay, so that's our understanding, that's our discussion. So this covers your right to speech, right to freedom. Now, in case you get an essay on freedom of speech and expression, I have sort of given you some points here itself which you can use in your essay. So in the very first part of it, I have given you a quote. I have given you a quote from the Menka Gandhi case that we will discuss, some basics of it, that democracy is based on free debate is based on freedom of speech and expression. You can paraphrase this quote and then you can use it. Some generic things on what your restrictions are and why is freedom of speech important. Sometimes they ask you questions like these in the mains exam. Why is freedom of speech important? These are your 4 points. They're poetic in nature. Like for example, it's a prime liberty. Second, so that you can create political accountability. Third, so that you can uplift the suppressions of the minorities. And fourth, it gives you the ability to the creative license to express yourself as well as you could, right? Of course. Then we've covered all of this, and this sort of gives closure to Article 19. Now, I wanted to lay down what our broad plan is going to be, and I think from tomorrow onwards, we're going to do a full 2-hour class because I want to finish your polity before the 10th of February or the 12th of February, and it is very possible. So the larger plan is this. The plan is that let us say today is the 28th. On 29th January, we will finish euthanasia, LGBTQIA, privacy, and uniform civil code. On 30th January, we will finish the doctrine of basic structure and harmonious construction. Okay. On 31st of January, we will finish, we'll start with, this will be the end of theme number 3, and I'll give you some analysis of the reservation policy on 30th Jan. On 31st of January, we'll start with the President, the Governor and Council of Ministers. This is going to take me a total of 2 days, including the analysis. So on 1st of Feb, we should be completing this. This includes elections, comparisons, everything. Once we are done with this, from the 2nd of Feb till about the 5th of Feb, we are going to spend some time on Parliament and state legislatures. Then on this, from the 6th to the 7th of Feb, center-state relations and separation of powers. 8th to the 9th of Feb, we will do judiciary. 10th Feb, we will do bodies. And 11th to the 12th Feb, 10th we will do local self-government. And 12th Feb, we will do bodies. So by, as promised, within the first week of Feb, we should be done, right? Okay. Current affairs should usually be in the introduction. The question is never on current affairs, but the background of it. Is this okay? Is this clear? So by the 10th of or the 12th of February, we would be done. Now, in case the lockdown opens up by the 9th or the 10th, and we just have 4 or 5 classes, what I'm going to do is I'm going to still continue with this online, because there is a there's a leniency to it, there's a rhythm to it, unless again otherwise the rhythm will get broken. So I want to finish it irrespective of what happens to the lockdown, and then in case some of you want physical classes, I'll arrange them for you. But as you know, I still think studying like this is more interactive, it's more clear, you can do a lot more information, and you actually discuss a lot more content like this than you actually do in an offline class. I don't know if you'd agree with me on this, but I would certainly agree with me on this. Right? Okay? Understood this? Sure? All right. Cool. Thank you.